If you've been through law school in the UK and I say to you Mongolian pony, what are you going to say back? Law Study 101 is learning about the basics of how the English legal system operates. This is relevant whether you are a first-year law student or preparing for the SQE. My goal today is to help break down the history, the structure, the key players, and give you the essentials for understanding the system as it stands in 2025. And the answer to the pony question is, of course, wigs. Barristers' wigs are traditionally made of horsehair, often said to be sourced from Mongolian ponies. There's one for some dinner table chit-chat. This podcast was prepared by Dr. Yannis. Have a look around his YouTube channel for more explainers of key legal concepts. So let's start with the absolute basics. What is law? At its core, law is a set of rules that we as a society agree to live by, and crucially, it's enforced by the state. There are consequences if you don't follow the rules. Think of it as the backbone of social order. It keeps things running smoothly. You'll often hear the phrase common law thrown around, especially when talking about the English legal system. This is a key difference between our system and many others, particularly in Europe, which rely on written legal codes in what we call a civil law system. English law is built on common law, which means a significant portion of it comes from decisions made by judges in past cases. It relies on building on previous rulings. It's like constructing a legal structure, but instead of bricks, we're using precedents. This leads to a fascinating debate about the role of judges. Some say that judges simply interpret the law as it is, but others argue that they have a crucial role in shaping it. A powerful recent example was the Supreme Court's landmark decision in April 2025 for Women Scotland No. 2 v Lord Advocate 2025 UK SC 16, which ruled that the protected characteristic of sex under the Equality Act 2010 refers to biological sex assigned at birth. That single interpretation has enormous social and legal consequences, showing how judicial decisions, while technically interpreting Parliament's will, can become a focal point for intense debate about the judiciary's power. It's a balance between sticking to precedent and adapting to societal change. This concept of precedent is formalized in what we call binding precedent. Think of it like a chain of legal decisions. What it means is that lower courts are bound to follow decisions made by high courts in similar cases. It's all about keeping the law consistent and predictable. Of course, there are times when a judge might want to deviate from a precedent. That's where distinguishing comes in. A judge might highlight subtle differences between the current case and the precedents in the facts or the legal reasoning to argue that the old ruling doesn't quite apply. It's a way of creating flexibility within the system. This all operates within a clear court hierarchy. We start with the magistrates' courts for less serious cases, then move up to the Crown Court for more serious crimes. Appeals go to the Court of Appeal, and right at the top we have the Supreme Court. It's a legal pyramid. But it's crucial to understand in 2025 that this structure is under immense strain. There's a severe backlog in the Crown Court. A National Audit Office report highlighted that the median time from an offence being committed to a case's completion was 355 days in late 2024. This is caused by a complex mix of factors, but a key one is a significant shortage of criminal law barristers and solicitors. The system is also facing financial pressures, with over 170 different court and tribunal fees increased in April 2025 to help cover running costs.
Separate from the main court structure, but running parallel to it, are tribunals. They handle specific disputes, often between individuals in the state, in areas like immigration or employment. They are administered by the same body, HMCTS, and are a core part of the state's justice system, designed to be more accessible and efficient. In a positive development, a national rollout of a family court reporting pilot began on January 27, 2025. This creates a presumption that accredited media and legal bloggers can report on family court cases, a major step towards transparency in a historically private area of law. So, who are the people that make this whole legal machine work? The lawyers, of course. The legal services sector is a powerhouse for the UK economy, employing around 368,000 people and contributing approximately £37 billion to the economy. As of August 2025, there are over 174,000 practicing solicitors in England and Wales. Traditionally, there's a division of labour. Solicitors are your first point of contact. They give legal advice, handle paperwork, and prepare cases. Barristers are the courtroom specialists, arguing cases before a judge. That's the traditional view, but those lines are blurring. We now have around 6,900 solicitor advocates who can argue cases in the higher courts. But it's not a simple story of progress. The main body representing them, the Solicitors Association of Higher Court Advocates, had to wind up in 2025, citing unsustainable financial pressures, especially on its criminal legal aid members. It shows the harsh economic realities of publicly funded work. This brings us to one of the most critical issues facing the system: access to justice. Legal aid is financial assistance for people who can't afford a lawyer, but cuts have made it much harder for people to get help. We're seeing more litigants in person, people representing themselves because they can't afford a lawyer. This crisis is directly linked to the court backlogs. A 25% reduction in government-contracted duty solicitors between 2017 and 2023 is a primary cause of delays. The problem isn't just in legal aid. A 2023 Supreme Court ruling in a case called PACCR, R Regulation versus Competition Appeal Tribunal, 2023 UKSC 28, made many litigation funding agreements for large class action lawsuits unenforceable, creating a crisis for funding big cases on behalf of consumers. Major reforms recommended in June 2025 to fix it, showing that access to justice is being fought on multiple fronts. Now, let's get into the substance of English law and its sources. We have statutes, laws passed by Parliament, and common law, which we've discussed. We also have the European Convention on Human Rights, but the relationship with former EU law has changed dramatically. Statutes are the most authoritative source of law we have. This is because of the principle of parliamentary sovereignty, the idea that Parliament has the ultimate power to make, change, or get rid of any law. In theory, its power is absolute, but in practice, there are political and international limitations. A perfect modern example of this sovereignty in action was the retained EU Law Revocation and Reform Act 2023. This act was fundamentally Parliament reasserting its authority over the law of the land. This brings us to the influence of European Union law, an area that has seen a massive and fundamental change. It is vital to get this right for 2025. For a long time, EU law had a special status, but the retained EU Law Act 2023 completely changed the landscape from January 2024. The entire body of former EU law is no longer called retained EU law. The correct legal term now is assimilated law. This is much more than a name change. The Act abolished the principle of the supremacy of EU law. Before, this body of law took precedence over conflicting domestic law. Now that's reversed. If there's a conflict, domestic law wins. This has created a period of significant legal uncertainty as thousands of laws are now open to reinterpretation by our courts without the old EU framework to guide them. It's not being worked out anymore. It's a new, complex, and uncertain legal reality.
And what about the European Convention on Human Rights? This is a treaty that protects fundamental rights and freedoms. It was incorporated into our domestic law by the Human Rights Act of 1998, and that act remains fully in force. For a while, there was a government proposal for a new Bill of Rights to replace it, but that plan was officially scrapped in June 2023. So individuals in England can still directly rely on the convention in our courts. The history of our legal system is long and winding. The story really starts back in the 12th century with King Henry II. He established a system of royal courts that developed a common set of legal principles, and their rulings became the precedents that formed the foundation of common law. But this system could be rigid, and sometimes applying the law so strictly led to unfair outcomes. That's where equity came in. It developed as a separate system to smooth out the rough edges of the common law, introducing concepts like injunctions to prevent harm. Although the courts were eventually merged, the principles of equity are still woven into how the system operates today. This evolving system is part of a unique constitutional framework. Unlike many countries, the British Constitution is unwritten. It's a jigsaw puzzle of historical documents like the Magna Carta, statutes, common law, and unwritten conventions. This makes it flexible, but also sometimes unclear, which is why the courts have a big role in clarifying it. The system is held together by core principles. We've mentioned parliamentary sovereignty. Another is the separation of powers, the idea that government powers spread between the legislature, parliament, which makes laws, the executive, the government, which implements them, and the judiciary, the courts, which interpret them. A recent example of this in action was the Supreme Court's 2023 decision in Imam v. Croydon, 2023 UKSC 45, where the court affirmed its power to order a public body to do its job, but also set out principles of restraint to avoid interfering with policy decisions that are properly left to the executive. The third key principle is the rule of law. This means everyone is subject to the law, no one is above it, and the law should be clear, predictable, and applied fairly. It's a fundamental safeguard against tyranny, and a big part of the judiciary's role is to uphold it. To do that, judges must be impartial and independent. This independence is protected by safeguards like security of tenure, meaning judges can't be easily removed from office. And unlike in some countries, our judges are appointed based on merit, not elected, to further insulate them from political pressure. There is, rightly, a lot of discussion about improving diversity in the judiciary, not just for fairness and representation, but because diverse perspectives lead to more robust legal reasoning and better quality justice. So, how does the legal process work in practice? A civil case is a dispute between parties, usually over things like contract breaches, and typically begins when a claimant files a claim against a defendant. If they can't settle, it goes to a trial where a judge makes a decision. A criminal case is brought by the state against an individual accused of a crime. The stakes are much higher, so the prosecution has to prove guilt beyond a reasonable doubt. It usually starts with an arrest, an investigation, and then a decision by the Crown Prosecution Service, the CPS, to charge. If the defendant pleads not guilty, it goes to trial, where in serious cases, a jury of ordinary citizens decides the verdict.
Of course, no system is perfect, and we must talk about miscarriages of justice. The most prominent example in our recent history is the Post Office Horizon IT scandal, the most widespread series of wrongful convictions in modern English history. Hundreds of sub-postmasters were wrongly prosecuted based on faulty accounting software. There's now a major public inquiry, and in 2025, the government established the Horizon Convictions Redress Scheme to provide compensation to victims. The scandal has also put the conduct of the lawyers involved under intense scrutiny, with the Solicitors Regulation Authority conducting over 20 investigations. It's a stark reminder that the system can fail. For those who've exhausted all other appeal options, there is a final safety net, the Criminal Cases Review Commission, or CCRC. Their 2024-25 annual report showed they received over 1,500 applications and referred 31 cases back to the appeal courts, showing how vital their role is as a final safety net. Lawyers themselves are guided by a strict code of ethics, based on principles like confidentiality, loyalty, honesty, and integrity. This is overseen by regulators like the Solicitors Regulation Authority and the Bar Standards Board. In 2025, regulation is under a microscope. The collapse of a large law firm, Axiom Inc., prompted regulatory scrutiny and a major consultation on consumer protection, including options that would reduce or even remove firms holding client money directly. That, combined with the investigations into lawyers' conduct in the post office scandal, means professional ethics is a huge focus right now. Finally, I want to touch on something that's changing the game: technology. The multi-year HMCTS reform program, which concluded in March 2025, has embedded technology into court operations. Electronic filing is common, and a new video hearing service is making remote participation a standard feature in many cases. In criminal courts, pre-recorded evidence technology became available in all Crown courts on 16 June 2025, allowing vulnerable witnesses to have their cross-examination recorded before the trial. Artificial intelligence has also moved from theory to a regulated reality. In April 2025, the judiciary published updated guidance permitting judges to use secure AI tools for tasks like summarizing documents, but strictly prohibiting its use for judicial decision-making. The Ministry of Justice has even established a dedicated Justice AI unit to explore its responsible use. The focus is AI as an assistant to augment human judgment, not replace it. As we look ahead, the English legal system faces several key challenges. The first is a sustainability crisis. Chronic underfunding has led to a shortage of legal aid lawyers, which is a direct cause of the unprecedented court backlogs. This fundamentally undermines timely justice. Second is the post-Brexit legal identity crisis, where the abolition of EU law supremacy has created a period of profound legal uncertainty. And third is a crisis of public confidence, driven by systemic failures like the post office scandal. I'll leave you with a question to ponder. What role should the law play in our society? How can we make sure the English legal system continues to uphold the values of fairness, justice, and the rule of law in a world that's constantly changing? It's a challenge, but an important one, and something we all have a role to play in. If you enjoyed this, have a look around Dr. Yannis' channel for more. See you next time.